going on and on. But with respect to our topic, the next point for which I would like to throw some light is that how the judicial activism was started in the field of environment protection. Dear friend, the court of the nation, they are the apex court, namely the Supreme Court of India, the various states high courts, and the other subordinate courts, plus the other authorities as covered under Article 12. These are the mechanism established by our Indian Constitution to protect the environment. This machinery or this mechanism is trying at most to protect this environment, any part of the environment. It may be air, water, land, human beings, etc. Supreme Court has delivered so many judgments which speak that the first duty of a citizen is to protect environment. If environment will not be protected by us, we will not be protected by the environment. We all know that the Fahrenheit the temperature in Fahrenheit or the temperature in Celsius is going higher and higher in the season of this summer. We are having lesser rain in our nation. We are having less cold in our nation. The word used for this kind of environment disturbance is global warming. This is the phrase used by some author to describe the pollution as prescribed or the pollution as measured in environment or in open space. We have polluted the environment in such a manner that there is an ozone hole is also found by the satellites or by the scientists of the nation, which is very destructive for the life of some small creatures. So at the level of state, the courts are also always ready and active to play his role as the environment protector. To discuss this judicial activism, I would like to show you a case relating to Article 21. In the case of Subhash Kumar versus State of Bihar AIR 1991, Supreme Court, page number 420, whereby the Supreme Court held that right to live includes right of enjoyment of pollution free water and air for full enjoyment of life. If anything endangers that quality of life, a citizen has right to have recourse to Article 32 of the Constitution. Dear friend, the meaning of Article 21 is expanded by this case of Subhash Kumar versus State of Bihar. Right to life includes right to live in pollution free environment, and if anyone endangers this right by any means, the constitutional remedies are available directly under Article 32. As Article 32 is there because the fundamental right is violated, the same way Article 2 to 6 is also there to protect the environment, to provide the constitutional remedy to the aggrieved person. Dear friend, as we are discussing about judicial activism with reference to environment protection, who can file this kind or who can ask for the remedy? Is it necessary that the person who is seeking this remedy must be the aggrieved party? No. If the citizen is the person who is not even aggrieved, not even affected by this environment pollution, but he can file a petition directly before Supreme Court or can file a petition before the High Court. The reason is Article 51, capital A, clause G. It is the duty of each citizen, whenever one wants to discharge this duty, there is the mechanism named public interest litigation. By that manner, one can file a direct petition before the Supreme Court or before the High Court. So, in public interest litigation, due to the provision of Article 51, capital A, clause G, one can file public interest litigation, and mostly the all environment cases are being filed as public interest litigation. In short, it is known as PIL. This PIL is valid because of some endangerment as created by other party is conceived as the public nuisance for the society. So, on the basis of this public nuisance, petition can also be filed as the third person to the claim, third person to the offense. So, by way of PIL, in this present case, Supreme Court expanded the meaning or the provision of Article 21, and it was led directly to the constitutional remedy under Article 32. Now, I would also like to discuss some few more cases before you. They are chronologically, I have arranged these cases as the first case relating to environment protection I will discuss is MC Mehta versus Union of India. Citation is AIR 1988, Supreme Court, page number 1037. This MC Mehta versus Union of India has a long list of PIL, amongst which this particular citation is relating to Ganga Pollution Tanneries Case. The second case I will discuss is Vellore Citizen Welfare Forum versus, in short I have written, Union of India. The citation is AIR 1996, Supreme Court, and the page number is 2721. And the third case, which is important, is again having the same name, MC Mehta versus Union of India. It is known as Taj Mahal case or Taj Trapezium case. The citation is AIR 1997, Supreme Court, page number 734. The first case of MC Mehta versus Union of India, which is known as the Ganga Pollution Tanneries Case, I would like to mention some fact of the cases, whereby the facts as shown in the petition are like this. In the region of Kanpur district, there were almost 70 small, medium or large kind of tanneries activities were going on nearby the Ganga river, and these tanneries activities were discharging the water effluents without being processed. So the effluents which were discharged by these tanneries activities, they were polluting the river of Ganga, and as the river was polluted, and the river Ganga is having an immense importance in the territory of India, and due to this tanneries activity, the sewage were just throwing, as the river Ganga is nothing but a big sewage canal. Dear friend, it was also ascertained, if I can read it from the paper, that it was observed that the effluent discharged from a tannery is 10 times noxious when compared with the domestic sewage water which flows into the river from any urban area on its bank. Dear friend, this is the fact. I am not stating by myself. These are the facts as contained in the petition filed by this MC Mehta versus Union of India case, that the effluents thrown into the river were 10 times noxious than the sewage pipe. If one village, if it throws its sewage pipe to somewhere, this particular garbage of this tanneries activity were 10 times noxious. Dear friend, these types of pollutants disturbs not only the quality of the water of the river but the living creatures of that river. And it is also the religious myth in Indian culture to throw the dead body in the water of Ganga so that the soul will get the final destination. It is also the myth or the custom. If I discuss it liberally, it is the Indian custom to sprinkle rather the ashes of the dead body into the river of Ganga. Then the soul of that dead body will get the final destination. The soul will merge with the supreme authority of the globe, of the universe. These are the customs. These customs were this polluting the river Ganga. These kind of customs, in addition to these tanneries activities, were also going on, whereby without any primary cleaning the garbage were thrown in the river. So the petition was filed by Mr. MC Mehta, the social worker, and Supreme Court held this tanneries activity as illegal. I would like to read the judgment from the slide, whereby Supreme Court also gave directions to set up effluent treatment plants within a period of 6 months. So the Supreme Court directed that the effluent treatment plants must be established within a period of 6 months in the tanneries activity which are established nearby the shore of Ganga. Further, the court also directed the central government, pollution control board and the district magistrate to oversee the work. So Supreme Court also established the legal duty of central government, pollution control board and the district magistrate that whether these kind of effluent treatment plants are being established within 6 months of period or not, and if the tanneries activity failed to set up these kind of primary treatment plants, then they will be closed immediately after the expiry of 6 months. Further, Supreme Court also held, or Supreme Court further observed, that just like an industry which cannot pay minimum wages to its workers cannot be allowed to exist, a tannery which cannot set up a primary treatment plant cannot be permitted to continue to be in existence for the adverse effect on the public at large. Dear friend, the Supreme Court connected industries with the environment pollution by way of that if any industry is not paying the minimum wages to its worker, that industry is not allowed to run its activity, then the same is applicable to protect the environment. If precautionary steps are not being followed by any industry, it has no right to continue its activity. So Supreme Court connected industries which is paying less wages to its worker and the industries running without any precautionary steps. Further, Supreme Court also held that the Kanpur Nagar Mahapalika has to bear the major responsibilities for the pollution of river Ganga. So the duty was also again established on Kanpur Nagar Mahapalika, as it is its responsibility to look after the quality of river Ganga. It is its duty to improve the quality, to stop this kind of pollution by establishing any rule or regulations for the protection of river Ganga. Dear friend, this is the first case of environment pollution which I have considered it important for the judicial role as protector of the environment pollution. Now I would like to discuss one another case which is also known as Vellore Citizen Welfare Forum. This case citation is Vellore Citizen Welfare Forum versus Union of India AIR 1996, Supreme Court cases, page number 2721. The facts are similar to the case of Ganga Pollution case. Here the river which was polluted by the tanneries activity was Palar, and it was situated near or in the state of Tamil Nadu. And this river Palar was polluted again by the tanneries activity which were established near the river of Palar, and the treatment which this activity owner was conducting is like this. The